Good afternoon. My name is John Burns, and I am an elder care attorney practicing in Decatur, Alabama. I'm pleased to join you today, albeit via video, but nonetheless, I'm looking forward to this presentation as it gives us an opportunity to discuss with you and to present a seminar dealing with ethics, and particularly the ethics that many of you in the social work community have to face on a regular basis. And one of the things that I wish to discuss today is legal capacity standards and considerations, because nowhere do we have the confluence of law and ethics and practical considerations and often emergent or exogenous circumstances as we do when faced with the fundamental question that is posed to you on an almost daily basis, and that is, can mama sign the will? So one of the things I want to talk to you about today as we begin our presentation are some of the learning objectives. One of the things I want to discuss with you today are the standards of legal capacity. And I want to understand the various clinical models of capacity. And I want you to be able to take that back and to observe and evaluate capacity with your patients. Also, let's understand some ways of perhaps enhancing capacity. And then finally, let's discuss some of the cutting edge developments in the area of supported decision making. Now, to that end, and at the outset, I can summarize this by basically saying what is in your materials. And that is that you as clinicians have an ethical obligation to understand the concept of decision-making capacity and the ability to conduct a basic assessment. Quite frankly, that is something you do on a daily basis and probably multiple times every day. So I want to discuss today some of the common misconceptions related to decision-making capacity, the potential errors that occur in clinical assessments, and suggest some ways that we may be able to incorporate the use of written advance directives. One of the basics of this area of the law is the fundamental right of an individual to make treatment decisions. And this stems from an individual's right of self-control over personal decisions. A patient must authorize any medical or surgical procedure that involves the touching of the patient's body. The failure of the physician, the surgeon, or any other healthcare provider to obtain that permission may subject that provider to an action, a legal cause of action, for battery or negligence. And that is why before procedures are performed, particularly invasive procedures, the physician is required to explain the procedure to the patient, the risks and dangers inherent to that procedure and collateral to the therapy in order to help make the patient, to help the patient make an intelligent and informed decision. And I will discuss today informed consent. The patient should understand the diagnosis, the nature of the proposed treatment, the risks that are inherent in it, the prognosis if the treatment is not undertaken, and any alternative methods in therapy, if indeed any exist. Now, disclosure is not necessary in those rare instances in which a patient may have waived the right to be informed, or it would have an adverse effect on the patient. Moreover, no disclosure is required in the case of medical emergencies, where the patient is unconscious or otherwise unable to make a decision, yet treatment is necessary. But the starting point of any analysis is the patient's right to control personal decisions. Our system of law, and indeed as that has been applied to the medical profession and to the social work profession, has historically and consistently affirmed the right of competent individuals to control decisions about what is done to their bodies. At the common law, Justice Cardozo something that probably means very little to you, but among lawyers, he's a rock star. And over 100 years ago, Justice Cardozo in a case called Schoellendorf said that every human being of adult years and sound mind has the right to determine what will be done with his or her own body. Now, that's our common law root. And from that flows the right of self-determination. And that has two logical extensions that are applicable today. One is the doctrine of informed consent, and the other is the right to refuse treatment. We don't hear a whole lot about the doctrine of informed consent. It's a given. It's implicit with what we do. But we do every now and then hear a lot about the right to refuse treatment, because nothing causes more angst, more anguish, and perhaps even more anxiety. And quite frankly, nothing sells the headlines quite as well as a case of refusal of treatment. So we'll talk about some of that. But first, I want to talk to you about the concept of capacity, because this is something that is often misunderstood. And it's misunderstood because there are two independent concepts. One is capacity, and the other is competency. Now, capacity simply refers to an individual's ability to understand the significant benefits, the risks, and the alternatives to proposed health care, and to make and communicate a health care decision. It is the ability to understand and appreciate what one is doing, whether it's in the healthcare context or whether it's in the context of executing a power of attorney, buying a car, selling a horse, whatever it may be. Does the person have capacity? But the reality is that on a regular basis, each of you is asked that fundamental question that I presented a few minutes ago, and that is Mama competent to make a will? Well, here's the good news. You don't have to determine competency. In fact, there is only one person who can determine competency, and that is the judge of probate with jurisdiction over your particular area. That is it. You don't do it. I don't do it. Physicians do not do it. And I've had this discussion and an ongoing debate with a number of physicians about this. I have one in particular that I deal with regularly who consistently refuses to give any type of determination about capacity when we have guardianships or conservatorships, because he believes that he should not make competency decisions. And I have to explain to him every time, I don't want you to determine if they're competent. The judge is doing that. I just want you to tell me if they have capacity to manage themselves or their affairs. And the answer is invariably, no, they don't. But nonetheless, he seems to get hung up on this concept of competency. But as noted, competency is not a decision that we have to determine. Capacity, on the other hand, is something that you will be called upon to determine and opine on a regular basis. So let's look at some of the legal standards of capacity. The fact is, capacity varies greatly depending on what we are asking someone to do. Basically, testamentary capacity is often seen by lay people as the highest level of capacity. Did Daddy have capacity to sign a will? Did he know what he was doing? Was Uncle Bob in his right mind? Was Aunt Jeanette, able to sign a will? But the fact of the matter is this: testamentary capacity, the ability to make a will, is not the highest level. At best, it's probably about mid-range. It simply means that someone understands what he or she owns, understands the natural bounty of their property, in other words, where the property would normally go, and the ability to understand and appreciate where they want to direct the property. If I ask most of my clients, and in fact, if most lawyers are truly honest, and they tell you, do your clients read every word of a will? The truth of the matter is they don't. And I can guarantee you, the longer the trust agreement, the less likely it is that the client is going to read, comprehend, and understand every clause, every phrase, every provision. And that's okay, so long as they've instructed you in terms of what the intent is. Or I should say, instructed me as far as their assets and as far as their intent and what they wish to achieve by that. We can incorporate all of that into the right document, whether it be a will or a trust. Similarly, donative intent or gifting capacity requires understanding what one has. And most importantly, it carries with it the understanding that once that gift is made, it is a complete and final gift, and they're not getting the property back. The highest level of capacity is probably something in the nature of contractual capacity, and maybe even the conveyance of real property and signing a power of attorney. All of those are deemed to include contractual authority or contractual capacity, which is the highest level. In other words, the ability to understand and appreciate the effect of what someone is doing, and the economic effect, and the fact that it is a binding and perhaps lasting or final agreement. The ability to enter into a healthcare power of attorney or an advanced care directive may require, depending on who's asked, a much lower level of capacity than most others. Because in that case, you have simply said that in the event of an end-of-life decision, this is what I want or I do not want to happen. And similarly, in the event that I cannot either make a decision on my own or I cannot communicate that decision, then I want my son, my daughter, my spouse, my best friend Bob to make those decisions for me. So frankly, it is a lower level of capacity. And that's a good thing, because the patient may meet a lower threshold of capacity, yet not be able to understand the nuances of a contractual situation. So we look at some of the clinical standards of capacity. And I won't bore you with this because you've studied this far more than I have. But one of the most common models is the Grisso model, which is in your materials. And this involves both a casual determination of capacity, a consideration of functional limitations or attributes, as well as an interactive component that looks at things in context. But I'll leave that to you and to further study. I do want to talk about some of the factors that may affect capacity, because the reality is this. When you're asked to determine a client's or a patient's capacity, you probably resort to something like the mini mental exam or some other standard that is your go-to. And that's fine. And if you're comfortable doing it, that's great. Capacity is far more than knowing one's name, the date, the birthday, or even the president. Those may be indicative, but those can also be programmed responses that you're seeking. The reality is, capacity requires much more than that. And it's also determined by a number of different factors. And some of these include, as you'll see in your materials, the variability of the client's state of mind, the client's or the patient's ability to understand and appreciate the consequences of the decision that the person is being asked to make, understanding that the decision may be irreversible, the ability to understand the substantive fairness of the decision. Oftentimes, and I don't see it nearly as much as I used to, and frankly, I'd prefer not to see it, and I think every lawyer would prefer not to see it. But invariably, on a somewhat regular basis, we have a situation in which there may be multiple children, and one of the children is in the community or is reliable and dependable and trusted. And perhaps another one is equally trusted but lives far away. But there's always, shall we say, the black sheep of the family who comes in and out of the parent's life at periodic times and depending on their need and circumstances. And the question there often is, well, I don't want to leave everything outright to that child, or I wish to disinherit that particular child. Or, what I rarely hear, but occasionally do, I want to leave everything to my eldest daughter. And I've talked with her, and she has told me that she will then distribute everything among the other children, and I trust her to do that. Well, I always have to counsel clients away from doing that, because no matter how much you may trust that child, there's no legal obligation for that child to act. And that goes to one of the issues of substantive fairness. Yes, I can design a lot of complicated trusts, and so can a lot of other lawyers. But at the end of the day, what I really like to see is the remainder to my children in shares of substantially equal value or to their issue per stirpiece. That's what I want to see, because that ensures the substantive fairness and equality of distribution. Another thing that determines that may be indicative of capacity is the decision fundamentally consistent with the client's lifetime commitments? In other words, if the client has never had a history of making large gifts, is now the time really to begin making those large gifts, particularly to certain organizations or people? And that's a question I have to ask myself. Does this make sense? We hear a lot about deathbed confessions and deathbed gifts, and yes, I've been to many a hospital and sat there with many other professionals in your capacity, and we've talked with patients, and we've signed wills, and we've done a lot of things at the last minute, and unfortunately that's necessary. But I always have to ask myself, is this consistent with their overall objectives? And then I have to ask myself, and you do too, what is the decision that is being made, and what is the applicable legal standard? And can the client articulate the reasoning behind his or her decision? If she can tell me, I don't want to leave everything outright to my son Jim because he has an addiction or a substance abuse issue, but I would like to leave it in trust for his benefit and have that doled out on a periodic basis by his brother and sister, I'm all for it. They can articulate their reason. And I think that's sound and logical and makes good sense. And again, as many of you know, but I do want to cover, there are a number of issues and factors that may affect capacity. Because as I said, capacity, or incapacity for that matter, is highly transitory. It is very subjective. Many clients, as you know, or patients, may have full capacity in the morning, but as the day wanes, and particularly as afternoon turns to evening, they get what we call sundowners. There's some confusion. I see that. I see that with my clients. I see it with your patients. I see it with the telephone calls that we get in our office from clients who may be in the hospital and have access to a phone, or they may be in some type of skilled nursing or assisted living facility. And it's particularly difficult at this time when most of these facilities are under quarantine. And while their families, no matter how well-meaning or intentioned or how much they have tried, talk to them on a regular basis, whether through telephone or even through FaceTime or some other video connection, nonetheless, many of their loved ones who are elderly are very much alone in these facilities, and that lends to confusion. It lends to stress, and that's one of the factors. Grief, major factor. Unfortunately, I have a client right now who is still grieving for her husband of many years, even though it has been nearly 2 years since his death. Pain, that is a major factor. Always consider the amount of pain that a patient may be in. The same is true of infections. We often see that with clients. Sensory impairment, particularly loss of sight and loss of hearing, may lead to a number of factors that may exhibit or manifest themselves as some form of incapacity. I cannot stress enough the effect of education and literacy as affecting capacity. And it's not necessarily what you think. Because in my practice, I'm fortunate to represent a wide range of individuals, those of limited education and means, and those of great education or great means, or both. And the fact is, I find incapacity evident in all individuals, regardless of their walk of life. Those who have limited education or literacy, and there may be some other cultural, ethnic factors built into that, may have some inherent issues understanding and comprehending what we're trying to do to protect their interest and those of their loved ones. But by the same token, those with greater education may have this very same level of incapacity, but due to their education, they're just able to mask it a lot better. So it truly does affect all individuals. And it's either manifests itself through an inability to understand, or in other instances that I see often, an ability to cover or mask through programmed responses, stock answers, stock questions. Now, obviously drugs, drug interactions, dehydration, malnutrition, delirium, disorientation, depression all factor in to one's capacity and have to be considered. Fortunately, most of those issues that we addressed are transitory, meaning that if they can be addressed and remedied, we may be able to restore the person to capacity, which will then enable them to make decisions, whether those be healthcare decisions or, in many instances, decisions about proxies, healthcare decisions, and even the ability to execute wills or trusts. Now, when you look at incapacity, yes, there are a number of issues that may temporarily cause incapacity. Incorrect medication, adverse medication interactions, fairly common. We see it, you see it all the time. Dehydration and malnourishment, something that affects so many of our clients, particularly those who are just on the cusp of being admitted to some type of skilled care. And it is amazing how many cases we've seen over the years in which someone has radically improved once they have proper nutrition. And of course, as I mentioned earlier, temporary sharp or chronic pain. But I do want to consider this concept of informed consent, because informed consent is the physician's legal obligation to make adequate disclosures of the medically recognized risks, benefits, and alternatives to any proposed diagnostic or therapeutic medical procedures, and also to allow the patient to make informed decisions and to give informed consent to these procedures. Effectively, informed consent in this context constitutes three requisite elements that must be found. Number one is voluntariness. Simply stated, the person must be able to exercise a free will or free power of choice without intervention or any element of force, fraud, deceit, duress, overreaching, or any other form of restraint and coercion. And fortunately, I don't see any medical professionals exercising any undue influence over patients. Secondly, the person must have adequate information. Now, all jokes aside, there's a majority rule and there's a minority rule. Now, the majority rule is what we call the reasonable physician standard. In other words, the physician must disclose the amount and the type of information that a reasonable, prudent healthcare professional would have disclosed under similar circumstances. The minority rule, on the other hand, is what we call the reasonable patient standard. And under that standard, the doctor must disclose the information that a reasonable patient in the same situation would need to make a voluntary and intelligent decision. And the third element of informed consent is simply decisional capacity. And that is, the patient must possess certain values and goals. They must be able to understand the factual information and the alternatives relevant to that decision. They must have the ability to reason and to deliberate about the choices and the consequences, and they must be able to make and to communicate the decision. I don't care how sharp the person's mind may be. Unfortunately, if they cannot communicate the decision to you or to the nurses, the physicians, or any of the other staff as to a course of treatment or consent to a procedure, then they will be deemed to be incapacitated. And therefore, any decision by them is effectively null and void because they're unable to make a decision. Typically, and this is based on research, it's also found after several years of practice that I found that there are typically 4 scenarios that arise that may address capacity. And the first one's a simple one. And it's the one we see about 90% of the time. And that is the adult is competent and they're conscious to make healthcare decisions. Well, that's a no-brainer. They have capacity, there's no question about it. The second one is one we see with some frequency, but that's due to part of the nature of our practice. And that may be the situation where you have an adult, perhaps someone who is developmentally disabled, but never had legal capacity to make a decision in the first place. What is far more common and what we have to address is the third scenario. And that is an adult that was once competent is no longer able to make the decision. And its extension is an adult that was once competent but is now either unconscious, and is now either conscious but incompetent or minimally conscious. So when we look at advanced care directives and we look at what we are trying to address and avoid, it is really that third and fourth scenario. So what we have to do is ask ourselves a few questions. First of all, is the patient actually incapacitated and unable to make a decision? Or can they not communicate that decision? All right, if so, then we have a capacity issue. All right, can we then identify the appropriate decision maker? Well, hopefully we can. If they've executed a good power of attorney at any point and they had capacity when they executed it, then we can probably identify who the decision maker should be. Now, fortunately, there are some defaults, and in many instances we can look at situations in which we can default to the spouse, or we can default to children or other individuals whom they trust and have had a trusted and fiduciary relationship. At that point, the burden really falls on the decision maker to determine the patient's wishes. And that's where the decision maker then has to weigh a number of factors and then make the decision. Now, as I mentioned, one of the most controversial decisions that has to be made, and what is most salacious and gets all the headlines, though it's probably the rarest, is the right to refuse treatment. Yes, it comes about from time to time. And yes, every living will that you see, including the Alabama statutory form and frankly the statutory forms in most other states, all contain provisions about whether someone wants or does not wish to have some form of artificial life support and artificial nourishment and hydration in the event of 2 circumstances, and that is terminal illness or injury or permanent unconsciousness. Well, Karen Ann Quinlan is the case that first gave rise to this. Now, most of you, I suspect, do not remember the Karen Ann Quinlan case, but I do. And I was about 10 years old when this case suddenly burst onto the national spotlight. And Karen Ann Quinlan was a young woman that had recently graduated from college, and she was celebrating. And unfortunately, a toxic mixture of pills and alcohol rendered her permanently unconscious and in a persistent vegetative state. Her parents very much wished to remove life support as well as the feeding tube from her to allow her to die naturally. The state of New Jersey, on the other hand, had I'm mistaken about Quinlan. They sought to remove the artificial life support, the ventilator, not the feeding tube. So the state of New Jersey had a very different view on this. And the state of New Jersey said that you can't do that. And in fact, they said, if you try to do that, let me tell you what's going to happen. we're going to arrest everyone involved and charge them with manslaughter. Well, needless to say, none of the healthcare professionals that were working with the case wanted anything to do with it. So the case ultimately made its way to the United States Supreme Court. And the U.S. Supreme Court held that this was a right to privacy. And it held that a patient's right to privacy under, in that case, the New Jersey Constitution outweighed the state of New Jersey's interest in preserving life. And in that particular case, a surrogate, namely Karen Ann Quinlan's father, could articulate her wishes and her interest about the direction of health care. And this was really the first extension that we ever saw of the right to privacy to the removal of life support. Now, for those of you who have studied that, or perhaps if you remember it, you know what happened. Life support was removed. The feeding tube was not. And Karen Ann Quinlan languished in a persistent vegetative state until, I believe, 1985, when she ultimately died. Now, a case of a little more recent vintage, at least 30 years ago, involved Nancy Cruzan. Now, if I recall correctly, Nancy Cruzan was a woman about 25 or 26 years old, and she'd had a horrific automobile accident in January of 1983 that also rendered her in a permanently unconscious state. Some of the same issues that we found in Quinlan also arose in the Cruzan case back in the early 90s. But the states had gotten wise, and the states said, you know, before you're going to remove artificial life support, or before you can remove a feeding tube, you're going to have to show us by clear and convincing evidence that that is what the patient would have wanted. In other words, it holds true to their moniker. Missouri's a show me state, and they basically said, you're going to have to show us that that was Nancy Cruzan's intent. Well, that case also made it all the way to the U.S. Supreme Court. And the Supreme Court said, you know what? Two things that were important. First of all, it said that food and hydration are equal to all forms of medical care. But the state did say, the U.S. Supreme Court did say, that states are permitted to set their own procedural safeguards, including a very stringent, clear, and convincing standard, which fundamentally all states have more or less adopted. But they also said that any expression of a patient's wishes may be valid regardless of whether it complies with the strict formalities of the law. So if there can be testimony as to a person's intent that they would or would not want a particular course of treatment, that may be admissible and considered by a judge if asked to determine what one's intent is. And that's why every power of attorney you see, at least of recent vintage, has those two provisions in its living will section about permanent unconsciousness or terminal illness or injury, and the withholding and withdrawal of artificial life support, and the withholding and withdrawal of artificially provided food or nourishment. And fundamentally, those two provisions all stem from these two cases. So the point of that case was basically any clear expression of a patient's wishes are valid, even if it's not in writing, even if it doesn't comply with what the state might otherwise want. As long as it can be proved and articulated, it can be admissible and considered. And in that particular case, on remand, the Missouri judge said, and after hearing additional evidence, the Missouri judge did permit the removal of the gastrostomy tube. Now, that is not to say that states do not have some state interest when it comes to the refusal of treatment. And there are, in fact, a few societal interests that will override a refusal of treatment decision. First of all, there may be instances in which the preservation of human life itself may override that decision, but that's somewhat of an amorphous decision. you may have the protection of third parties. Normally, sometimes minors, many instances an unborn child that may override a refusal of treatment decision. We may do it in order to prevent suicide. And then finally, and also somewhat amorphous, is the protection of the integrity of the medical profession. Now, perhaps the most recent case of any notoriety was the Terri Schiavo case, and this case arose out of Florida. Now, it was sort of the last of that trilogy. There have been some other cases along the way, and I won't bore you with a lot of the details, but the case actually had the attention of both the state of Florida, whose governor at the time was Jeb Bush, and the U.S. government, whose president at the time was George W. Bush. Both U.S. Congress and the Florida legislature introduced special legislation to address this particular topic because the case was unique. It didn't necessarily plow any new ground that Quinlan and Schiavo did not, but it did involve a dispute between family members as to what Terri Schiavo's wishes would have been in such a situation. And the risk that many ethicists have opined is that had the Schiavo case been over, if the ruling had been different, it could have threatened the very fabric and standing of both the Quinlan and Cruzan decisions. But there were a few key issues. First of all, one concerned the diagnosis of a persistent vegetative state, its concept and its meaning. The appropriateness in that case of Terri Schiavo's husband as the surrogate decision maker. Now, let me say at the outset, it was not simply that marital relationship in and of itself that gave him any greater ability to make the decision. What happened was, as a result of that, he had been legally appointed as a court guardian. And so on the basis of his being court appointed as the guardian, he was then given some superior right in regard to making legal decisions. There was a finding by clear and convincing evidence that Terri did not want to be kept alive in her condition, and it also affirmed what Cruzan had, which was a characterization of artificially provided nourishment and hydration as medical treatment. Now, enough of boring you about law stuff. Let's move on to the other side of that coin, and that is this: the right to demand treatment. Now, occasionally I will have a distraught family member in my office who, through tears and anguish and maybe beating fist on the table, will say, I demand this type of treatment be given to my fill in the blank. Husband, wife, child, parent, you name it. The fact of the matter is this: ethically, and you probably do face this far more than I do, but there is no ethical obligation on the part of any medical professional to offer or administer any treatment that has no or limited benefit. In other words, there's no ethical obligation to offer or to administer treatment that has no possibility or benefit to offer a physiological benefit relative to the patient's diagnosis, prognosis, or medical condition. To introduce a treatment burden without the possibility of benefit causes harm and misuses resources. Now, you have to be sensitive in these situations. And unfortunately, we're all human, and we all get caught up in the emotion and the moment. But the reality is this: the practical answer is simply to say, in many instances, it is not to characterize the treatment as non-beneficial or futile, though it may be, because these terms don't explain why a particular treatment would fail. In talking with professionals in your capacity about this, they basically said that the treatment cannot provide or they say basically that a treatment that cannot provide a physiological benefit is not the standard of care. And one should not use a treatment with no potential for a physiological benefit in an effort to simply deliver some psychological benefit to the decision maker. And that leads to decision-making standards. There are two fundamental variants with decision-making standards. In many instances, I will have clients, and I'm sure you see patients, their children, their spouses, say, we want to do whatever is best for mama. We want to do the right thing. The reality is this. The standard of decision making, as I said, has two variants. The first and the leading standard right now is what we call substituted judgment. Only if we can't determine what one's judgment would have been can we then fall back to what many of us were originally taught, which is the best interests standard. Now, the substituted judgment standard is highly subjective because it requires a surrogate decision maker to make a treatment decision in the manner that the patient would have made if the patient were capable of speaking for himself and herself. Now, by extension, that clear and convincing standard that Missouri had in that Cruzan case, and that most states, including Alabama, have adopted implicitly, or at least de facto, implies that there be substituted judgment. We have to determine what the decision would be that the person would have made if they were either capable of making the decision or able to communicate that decision. Now, the best interest standard, on the other hand, is a different standard altogether. If we can't figure out, and if the decision maker doesn't know what the substituted judgment decision would be, then we can default back to their want to do what's best. Just want the best for mama. I just want the best thing for daddy right now. And the best interest basically says that we're going to promote the patient's interests as they probably would have been determined by some reasonable person. But it takes into consideration a lot of different factors. And those factors include what the patient is experiencing at that moment, or what is more likely, what we think the patient is experiencing at that moment. There is an ethical imperative to relieve suffering. And we also have to consider what most patients of similar age, condition, diagnosis would experience as the benefits or the pitfalls of such a treatment. Is there anything unique about that patient? What are the treatment options that have a realistic potential for benefiting the patients? What are the benefits and the burdens of each treatment option? And then finally, what other values, and this is highly subjective, could a reasonable person consider? And most states, including Alabama, do recognize a good faith effort to determine wishes on a continuum running from the best analysis, subjective or judgment on the one end, all the way to best interests on the other. Now, in the time we have left, which is about 20 minutes or so, I want to talk about some other aspects that are important that affect your practice, either directly or indirectly. One of them is what we call the Patient Self-Determination Act. Now, contrary to what you may have read or understood or maybe even been threatened with, I don't know, the Patient Self-Determination Act only, or I should say, is simply an information and education act only. It does not impose some substantive law regarding advance directives. It simply says that certain information must be elicited from and provided to patients at all hospitals, nursing homes, home health agencies, managed care organizations, that participate in Medicaid and Medicare. So it is simply, as noted on the slide, an Information and Education Act, nothing more. There are 5 elements of it, and this probably explains a lot of the paperwork that the admissions coordinators put in the record, and that many of you have to address and wonder, why is all this paperwork in here? The first is you have to give written information about the right to make medical decisions and formulate an advanced care directive. A hospital such as yours has to maintain written policies with respect to advanced directives. You have to document in the record whether that patient has an advanced care directive. It ensures compliance with state law regarding advanced care directives, and it is designed to provide for education for staff and community and persons in the community regarding advanced directives. And that leads us to the topic of advanced directives. There are a number, and you see them all. And quite frankly, in 30 years of practice, I've yet to figure out which is truly the best. Yeah, I like the Alabama statutory form. I think it's really good. I like the Tennessee form too for my clients up there. Though over the years I've incorporated some of my own, and I'm a lawyer, I get paid by the word, so I might as well tinker with it a little bit. And I'm not going to change the fundamental questions they're asking and all the elections they're asking, but I may get in there and I may tinker with and change the HIPAA provisions and make them a little broader, or extend them out to people, the right to disclose medical information to people who are non-decision makers, which I'm sure gives you and many others fits, but it's what we do, it's what we like to do, so just bear with us and let us just humor us. But the thing to understand about any healthcare power of attorney, and whether it's the Alabama statutory form, whether it is simply a short form, it doesn't matter. Fundamentally, it is a contract. And courts will rely upon a standard of contractual capacity if the capacity of the patient making that healthcare power of attorney is ever challenged. Does the person possess sufficient mind to understand in a reasonable manner the nature, the extent, the character, and the effect of the particular transaction in which he is engaged, and whether he is competent to transact business generally? Now, fortunately, some states, not around here, however, but Vermont, Utah, have very clear statutes on the subject. And that means, what does it mean to have another individual make healthcare decisions for oneself? Who would be appropriate to make those decisions? And the ability to identify whom the individual wants to make those decisions. That's why we have to put a lot of contact information in our forms, so we can make sure that in the event that healthcare power of attorney ever has to be used and the decision maker is not standing nearby, that we can find that person. So on the one hand, you have a healthcare power of attorney. Typically it's a form. Frankly, in my middle age now, I like short forms. I like them real short, real simple, and make it very clear that I'm giving all power to a particular individual to sign. And in fact, depending on the overall capacity of my client, I may have them sign a simple form as opposed to the longer Alabama statutory form, because that statutory form, which is very good and very well reasoned, calls for them to make about 9 or 10 elections, if I recall correctly. And sometimes that may be about 8 elections too many for many of them, particularly if they can just sign their name and know they want to appoint their son, their daughter, or all their children to make decisions. Fortunately, in Alabama, it does not require notarization. It can simply be witnessed. It can be witnessed. Well, it can be witnessed. As a precaution, I frankly have it witnessed and then I have it notarized, because that's going to cover any base. Healthcare directives and any power of attorney or will be valid in any state so long as it was valid in the state where it was executed at the time it was executed. But quite frankly, I just really like to mitigate any risk and remove any null doubt. So I'll put witnesses and I'll put notaries on there, and that usually should take care of most instances. Now, there's another great document that Alabama's experimenting with, and I really wish they would adopt it, though it does have some limited utility, or at least life, and that is a POLST, Physician Orders for Life-Sustaining Treatment. The great thing about a POST, or a POLST, is that it is the result of an ongoing dialogue between the treating physician and the patient regarding end-of-life decisions, to the extent that the physician can actually put that down in the form of an order that is basically part of the electronic record and part of the physical record. In fact, most states mandate that it be printed on a particular pastel, a pink sheet, or a green sheet, or something that makes it stand out. The other advantage is this, and I'll talk about this in a few minutes, and that is the advantage of physician orders for life-sustaining treatment is simply that it travels with the patient. So as the patient may go from home to the hospital to rehab to a skilled nursing facility, that record travels with that patient every step of the way. Now, the final document on your slide is the living will. Now, in our case, we incorporate in every event that we can the living will with the healthcare power of attorney to create that advanced care directive. But they can be separate documents, and in fact, you see them as separate documents with some frequency just to the north in Tennessee, because Tennessee likes to have separate documents for every decision. And so you may have, if you see one from Tennessee, it may simply be just a living will. And the living will incorporate or encompass the same decisions that it does in Alabama: artificial life support, artificially provided food, nourishment, and hydration, and the two scenarios, terminal illness or injury or permanent unconsciousness. Tennessee, and you probably do see that since your hospital serves that area, does have another decision that the patient has to make that Alabama does not require, and that is namely organ donation. And that was driven in large part by the fact that there are obviously a few very large med centers in Tennessee, both Vanderbilt, another one in Nashville, and then of course the University of Tennessee hospitals, both in Knoxville and Memphis, that do a fair amount of transplant surgeries, just as UAB does. But those hospitals were successful in getting those decisions built into the Tennessee forms. As I said, reciprocity is usually not an issue. If it's valid where it was signed, it's going to be valid where it's implemented. It becomes effective. It's usually effective immediately. Unlike a regular power of attorney, it is not springing. It becomes effective immediately, but again, so long as the individual can make a decision, in other words, have capacity, and communicate that decision, it doesn't really matter what it says. It may be valid, it's just not fully effective. And as long as the person has capacity, it can be revoked. There are a lot of pros and cons you'll see with advanced care directives, and you may be asked about this from time to time. The big advantage of any type of advanced care directive is it can support a process of advanced care planning. But the problem is most people don't complete it. I can't tell you the number of people who won't do it. It's much like a colleague of mine whose father was a renowned and respected nationwide tax practitioner who had a will that was like 40 years old, and he never bothered to update it. The reality is most people don't do it. And invariably, I'm dealing with individuals, and you are too, because we deal with the same people on a regular basis, that their children say, we don't know, there is nothing in place. And at that point, it may be too late, or there is such recalcitrance that the parent simply will not sign, even if they have the capacity to do it. They're simply unwilling to do it. I went through that recently with a close friend of ours, whose mother adamantly refused to sign despite the fact that she had a debilitating condition, and she only had one person she could give the power to. So anyway, One of the other advantages is it can empower and educate a healthcare agent. And that's one of the things I like about Alabama, that healthcare agent actually has to sign the form. So we avoid the issue in which the agent is completely unaware that they have ever been appointed. And we always make sure the agent has a copy of all the forms. Yeah, I think to some extent, one of the advantages of advanced care directives is it can influence care and services. But the reality is you, the nurses, the doctors, the folks in the ER, the folks through treatment, all the way through rehab, may be completely unaware of the existence of that form. So it really is not doing anybody any good. So I've spoken for the better part of, I think, 55 minutes now, which I think may satisfy our minutes for your CPE. The proctor for this will have my email address, and I certainly hope that as a result of that, you will email any questions you have about this, topics we've covered, perhaps topics we have not covered. And because you all are on the front lines of this, you are facing hard decisions, difficult decisions every single day, and capacity and decision-making ability are crucial. And those are decisions that you're frequently asked to opine about. So I hope that today's presentation regarding the ethics of decision-making and considerations has been helpful, and I hope it will be useful. And please call or email with any questions, and I'll respond as soon as I can. Thank you very much.